You spent years earning a degree in a field the United States desperately needs. You found an employer willing to sponsor you. You registered for the lottery, and then you waited, and then you did not get selected, and then you did it again. The H-1B visa is the most searched employment visa in the United States and one of the most misunderstood. The headlines about a $100,000 fee have created panic in communities where most people will never pay it. The lottery uncertainty has pushed talented professionals toward decisions they should not have to make. In this video, we are going to cut through the noise, how the H-1B actually works in 2026, what the fee really applies to and who it does not touch, how OPT bridges the gap, and what your options are if the lottery does not go your way. We've put the questions and timestamps on screen so you can jump to what matters most.
The H-1B is a non-immigrant visa that allows US employers to hire foreign workers in specialty occupations. These are roles that require the theoretical and practical application of highly specialized knowledge, typically at least a bachelor's degree or its equivalent in a specific field. It is widely used across technology, engineering, data science, finance, architecture, medicine, and many other professional fields, where demand for skilled talent exceeds domestic supply. There is a strict annual cap of 85,000 visas, 65,000 fall under the regular cap. An additional 20,000 are reserved for beneficiaries who hold a US master's degree or higher. Applicants with a US advanced degree are first entered into the 20,000 master's exemption pool. If not selected there, they are automatically entered into the regular 65,000 cap lottery, giving them 2 chances at selection. The process begins with electronic registration in March each year. Employers register their prospective employees. USCIS conducts a weighted selection that favours higher wage levels. Those selected then have the opportunity to file the full H-1B petition. If approved, H-1B status begins on October 1st of the same year. Attorney Chris M. Ingram works with both employers and foreign professionals navigating this process. His view on the current landscape: the H-1B remains one of the most powerful pathways for specialty occupation professionals, but the environment has changed significantly. Higher fees for some petitions, expanded vetting, increased site visits, and a weighted lottery system all mean that preparation and strategy matter more than they ever have.
Just a quick reminder, if you appreciate this kind of in-depth content, please take a moment to like and subscribe. It helps us bring you more content. Now, on with the video.
I'm incredibly grateful to my attorney and the entire team for their outstanding work in getting my EEB 1AI 140 approved. From start to finish, they were professional, thorough, and genuinely invested in building a strong case for me. A special mention to Jenny Roncino, my caseworker, who was always there to guide me through every step. She was prompt, detailed, and extremely supportive in addressing all my questions and requests. Also, a big thanks to Miguel Farias, the case supervisor, whose excellent coordination and constant availability made the entire process smooth and stress-free. I truly appreciate the dedication, responsiveness, and expertise of this team. Highly recommended to anyone seeking top-notch immigration legal support. Kapildev. I had a fantastic experience working with the law offices of Chris Ingram on my EB-1A petition. From start to finish, the team showed exceptional professionalism, clarity, and care. My caseworker, Jenny Roncino, and case supervisor, Miguel Farias, were both incredibly thorough and knowledgeable. They took the time to understand the nuances of my case, guided me through the evidence preparation process, and answered every question I had with patience and confidence. I wholeheartedly recommend Chris Ingram's team to anyone navigating the complex U.S. immigration process. Their experience, integrity, and personal touch truly make a difference. Bangad. Those reviews represent professionals who navigated this process successfully. Now let us walk through how one journey actually worked.
Feeling lost in a maze of visa types and paperwork? Don't know where to turn? We've got your back. With clear answers and real help, we'll guide you every step of the way. Let's navigate it together. Your journey starts today.
Hello, you must be Clara. Welcome to the law office of Chris M. Ingram.
Finally,
I found a law firm that will help me achieve my American dream.
At this law firm, you are important to us. That's why we will be with you every step of the way. So join us at the office of Chris M. Ingram.
Valentina Greco grew up in Bologna, the daughter of a university professor and a civil engineer. She completed her undergraduate degree in computer science at the University of Bologna, then was accepted into a master's program in data science at Carnegie Mellon University in Pittsburgh. She arrived in the United States in the autumn of 2022 on an F-1 student visa. She graduated in May 2024 with a specialization in machine learning systems for financial risk modeling. In the final semester of her program, she interviewed with a mid-sized fintech company based in New York and received an offer as a data scientist. The role was exactly aligned with her graduate research. The company wanted her to start as soon as possible. There was one problem. Her F-1 visa allowed her to work on optional practical training, known as OPT, for up to 12 months after graduation, extendable to 36 months in total for STEM degree holders. But the H-1B lottery registration for the coming fiscal year had already closed. Her employer could not file an H-1B petition until the next registration window opened in March 2025, with an earliest possible start date of October 1st, 2025. Valentina started working at the fintech company in July 2024 on her OPT. Her employer registered her for the H-1B lottery in March 2025. She was selected. A petition was filed in April 2025. Her H-1B status began on October 1st, 2025.
Her husband Marco, a structural engineer who had been working in Italy, joined her in New York in early 2026 on a dependent H-4 visa. He has since applied for an H-4 employment authorization document, which will allow him to work while Valentina's H-1B remains valid. The entire process from OPT to H-1B approval unfolded without Valentina ever leaving the United States. She did not pay the $100,000 fee. Her employer paid standard government filing fees of approximately $2,000 to $4,000 plus optional premium processing. When clients read the headlines about the $100,000 fee, the team is often the first call they make. The answer they receive is almost always the same. For professionals already inside the United States on F-1 OPT or another valid status, the fee does not apply. Understanding why requires understanding exactly what the fee covers and what it does not.
Let us now walk through the 5 most important H-1B questions we hear constantly and give you precise answers to each one. Number 5. What does the $100,000 fee actually apply to? In September 2025, a presidential proclamation introduced a supplemental fee of $100,000 for certain new H-1B petitions. The scope is specific. The fee applies only to new H-1B petitions filed for beneficiaries who are physically outside the United States at the time of filing and do not hold a valid H-1B visa. It does not apply to change of status applications filed while the person is already inside the U.S., provided the petition requests a change of status and not consular processing. It does not apply to extensions or amendments approved for beneficiaries inside the U.S. As of June 2026, the fee's legal status is actively contested. A federal court struck it down on June 8, 2026, ruling in the court's own words that the fee functioned as an unconstitutional tax imposed without the congressional approval required by law. Days later, the same court temporarily reinstated the fee pending the government's appeal to the First Circuit. The outcome of that appeal will determine whether the fee survives. Employers with consular processing cases should work with Immigration Counsel to monitor developments in real time. What has not changed is this. For professionals filing a change of status from inside the United States, which covers the vast majority of F-1 OPT graduates, the fee has never applied and continues not to apply, regardless of how the litigation resolves. According to figures cited in federal court proceedings by Department of Justice attorneys, only approximately 70 companies paid the fee since it took effect in September 2025. That is a tiny fraction of the hundreds of thousands of H-1B registrations processed each year. Attorney Chris M. Ingram addresses this directly with clients. The $100,000 fee has created genuine fear in communities where it almost never applies. For someone on F1 OPT filing a change of status, the employer is paying standard filing fees, not $100,000. Understanding the actual scope of the fee is the first step to making a clear-headed decision. Number 4. How does OPT bridge the gap between graduation and H-1B approval? OPT, optional practical training, allows F1 students who have completed their degree to work full-time in their field of study for up to 12 months, extendable by a further 24 months for STEM degree holders, giving a total of up to 36 months of work authorization. This is the bridge that allows most international graduates to begin working legally in the United States, while they wait for H-1B registration, selection, and approval. The timeline works as follows. A student graduates in May or June. OPT begins. The employer registers the employee in the March lottery for the following fiscal year. If selected, the petition is filed in April. H-1B status begins October 1st. The employee has been working continuously on OPT throughout and transitions to H-1B status without ever leaving the country. For STEM degree holders, the 24-month STEM opt extension provides enough runway to survive 2 lottery cycles if necessary.
Number 3. What are my realistic chances in the lottery? The H-1B lottery remains competitive. In recent years, registration numbers have fluctuated as USCIS implemented measures to reduce duplicate registrations, and the weighted system gave US master's degree holders 2 chances at selection. Selection rates vary by year and by the total number of registrations received. Having a US master's degree improves your odds meaningfully by giving you access to both the master's exemption pool and the regular cap pool. Working with a cap-exempt employer, such as a university, a non-profit research institution, or a government research organisation, removes the lottery entirely. These employers are not subject to the annual cap and can file H-1B petitions year-round. Number 2. What should my company know about the current H-1B environment? Employers sponsoring H-1B workers in 2026 need to understand 3 developments. First, USCIS site visits have increased significantly under the current administration. Officers may visit the worksite to verify that the job duties, location, and working conditions match what was represented in the petition. Accurate, detailed job descriptions and up-to-date records of work location are essential. Second, social media review was expanded in December 2025. Applicants going through consular processing abroad should be aware that publicly available social media content is now reviewed as part of the visa adjudication process, and accounts must be set to public before the consular interview. Third, the weighted registration system means that each individual beneficiary can only be registered once per fiscal year across all employers, and selections are weighted toward higher wage levels, reducing the advantage previously held by employers filing low-wage or entry-level registrations.
And number 1, what are the best alternatives if the lottery does not select me? Attorney Chris M. Ingram answers this question every week. The strongest alternative for professionals who demonstrate exceptional achievement is the O-1A visa for individuals of extraordinary ability. The O-1A has no annual cap and no lottery. It is available year-round. It requires demonstrating extraordinary ability through evidence of awards, publications, critical roles, high salary, peer review, media coverage, original contributions, or membership in selective associations. For professionals earlier in their careers who may not yet meet the O-1A threshold, a cap-exempt employer, such as a university, teaching hospital, or non-profit research institution, removes the lottery barrier entirely while allowing the professional to continue building the record that may later support an O-1A or an employment-based green card filing. Attorney Chris M. Ingram concludes, "At the law offices of Chris M. Ingram, we help both employers and professionals navigate the H-1B process effectively, whether through the standard OPT change of status route, the O-1A for exceptional talent, or strategic planning around the current regulatory environment. The right pathway depends on the specific profile. The wrong pathway is making a decision based on a headline."
Attorney Chris M. Ingram is often asked, "I am from India and I know the green card backlogs are severe. If I get an H-1B approved, am I just buying myself more time in a queue that moves very slowly? You are asking this because you have done the math and the numbers are discouraging. Attorney Chris Ingram's answer is honest. The H-1B is a non-immigrant visa. It stabilizes your status and allows you to work legally while your long-term immigration strategy develops. For Indian nationals in the EB2 or EB3 backlog, the H-1B buys the time needed to assess whether your profile supports a faster pathway. The EB1A Extraordinary Ability Green Card has no per-country backlog for any nationality, including India. For professionals who have been building a strong record, publications, peer review, original contributions, leadership roles, the H-1B years may have quietly built a profile that supports an EB1A filing that bypasses the backlog entirely. The law offices of Chris M. Ingram assesses this question for Indian nationals at every consultation. Attorney Chris M. Ingram is also asked, "My employer says they cannot sponsor me for an H-1B because they are too small and do not want the risk. What are my options?" You are asking this because the employer you want to work for is willing to hire you but not willing to navigate the sponsorship process. Attorney Chris Ingram's answer is practical. Cap-exempt employers, universities, non-profit research institutions, government research organizations can sponsor H-1B petitions without the lottery and without many of the compliance burdens that make smaller employers hesitant. If your field has an academic or research dimension, a position at a cap-exempt institution is worth exploring seriously. For professionals with stronger profiles, the O-1A is an employer-sponsored visa that some smaller employers are more willing to support because it does not carry the same compliance infrastructure as H-1B. And for professionals who can self-petition through the EB2 NIW or EB1A green card pathways, the employer sponsorship question becomes less central to the long-term plan.
And one more question Attorney Chris M. Ingram hears constantly. I was not selected in the lottery. Should I just wait and try again the following year? You are asking this because waiting feels like the safest option, and you are not sure what else you can do. Attorney Chris Ingram's answer is direct. Waiting is sometimes the right answer, and sometimes an expensive mistake. It depends on how much OPT runway you have remaining, whether your employer is willing to explore cap-exempt options or O-1A sponsorship, and whether your profile has developed to the point where an O-1A filing is now viable. 12 months is a long time to lose if there is a stronger pathway available. The law offices of Chris M. Ingram reviews profiles for H-1B alternatives regularly and will give you an honest assessment of which options are actually available to you before you commit to another year of waiting.
If the H-1B lottery does not go your way, or if your employer cannot or will not sponsor you, there are pathways that keep your career and your immigration status moving forward. Pathway 1, the O-1A visa for individuals of extraordinary ability, no cap, no lottery, available year-round. For professionals who have built a record of achievement, including awards, publications, peer review, significant contributions to their field, and a high salary relative to peers. The O-1A is the most powerful non-immigrant alternative to the H-1B. It provides a 3-year initial period with unlimited 1-year extensions. Many professionals who assumed they did not qualify for the O-1A discover, after an honest assessment, that their record is stronger than they thought. Chris Ingram's team evaluates O-1A eligibility for every client whose H-1B situation is uncertain. Pathway 2, cap-exempt H-1B employment. Universities, non-profit research institutions affiliated with universities, and government research organizations are exempt from the annual H-1B cap. They can hire H-1B workers at any time of year without lottery participation. For professionals in technology, data science, engineering, medicine, and research fields, a position at a cap-exempt institution, even temporarily, removes the lottery uncertainty entirely and can serve as the bridge that allows the longer-term immigration strategy to develop on a stable footing.
If you are on F1 OPT right now, understand your timeline precisely. Know your OPT expiration date. Know whether you qualify for the STEM OPT extension and how long it gives you. Know when the next H-1B registration window opens and confirm with your employer that they plan to register you. That timeline is the foundation of every decision you make in the next 12 to 36 months. If you were not selected in the most recent lottery, do not make the decision to leave the United States or change your plans before you have had a genuine conversation about alternatives. O-1A eligibility, cap-exempt employment, and self-petition green card pathways are all options that deserve an honest assessment before you conclude that waiting is the only path forward. If you are an employer navigating the current H-1B environment, with increased site visits, social media review, accurate job descriptions, and the $100,000 fee question for overseas hires, the compliance picture has changed significantly. Chris Ingram's team advises employers on building H-1B programs that are accurate, defensible, and strategically sound. Visit breakthroughusa.com to schedule a consultation and get a clear picture of where your H-1B situation actually stands.
Valentina's machine learning models are now being used to flag early indicators of credit default risk across a portfolio of several 100,000 accounts. The work she came to the United States to do is being done. Marco has now passed his professional engineering equivalency assessment. His H-4 EAD application is pending. Their apartment in Brooklyn has a view of the Manhattan skyline that neither of them takes for granted.
The $100,000 fee that consumed 3 weeks of anxious reading did not apply to them. The lottery that consumed 2 registration cycles ultimately worked. The OPT that bought the time needed to let it work did exactly what it was designed to do. The system is complicated. The headlines make it more frightening than it needs to be for most people. The right information at the right moment with the right strategy behind it, that is what changes outcomes. If you are navigating any part of this process, the most valuable thing you can do right now is understand exactly where you stand, not where you think you stand, not what you read in a headline, where you actually stand based on your specific profile, your current status, and the options that are genuinely available to you. That is what a consultation with attorney Chris Ingram's team is designed to give you: a clear picture, an honest assessment,